We often talk about Supreme Court cases that shift the tectonic plates of American policy. Big things like abortion rights, voting rights, immigration. But today, we're doing a deep dive into a decision that changes something, well, arguably more fundamental. The actual rules of the legal fight itself. High-stakes stuff.
That's exactly right. This case isn't about what the government can do, ultimately. It's about how quickly and how broadly the courts can actually stop the government from acting.
So less about the policy, more about the referee's whistle, in a way.
Precisely. And for you, the listener, this is really essential. This deep dive focuses entirely on this procedural hammer that federal courts have been using more and more over the past few decades, the universal injunction.
Right.
We are unpacking the Supreme Court's decision in Trump v. Cy Inc., which just drastically limited this huge power.
Okay, so our mission today is to understand why the court decided to lean so heavily on, centuries-old legal history to limit this very modern tool.
Yeah, that's the core of it.
And we need to figure out what a universal injunction actually is, and crucially, what this procedural change means for, ordinary citizens, organizations trying to challenge federal policies going forward. All right, let's set the scene. What was the actual policy that kicked all this off?
The challenge started with an executive order, EU 14160. It was titled, Protecting the Meaning and Value of American Citizenship.
Okay, sounds pretty sweeping.
And it stepped right into one of the most, contentious constitutional debates we have, birthright citizenship. It was basically an attempt by the executive branch to say, hold on, under these specific circumstances, being born in the U.S. doesn't automatically make you a citizen under the 14th Amendment.
So what were those specific circumstances? Let's dig into the details there. What criteria did the EO use to sort of challenge that automatic citizenship?
Well, it focused on two groups of children born here in the U.S., specifically where the father wasn't a citizen or a lawful permanent resident. The EO aimed to deny citizenship if the mother was either 1, unlawfully present, or 2, if she was lawfully present, but only temporarily. Think student visas, tourist visas, that kind of thing.
Right, okay. Predictably, I imagine this sparked immediate legal battles. High-stakes stuff.
Absolutely. Instantly. You had 3 separate lawsuits filed, individuals, organizations, even several states jumped in. All of them argued the EO violated the 14th Amendment Citizenship Clause and also the older Nationality Act of 1940.
And given the potential impact, the citizenship of thousands of newborns hanging in the balance, the lower courts had to react quickly, right?
They did. They responded with, maximum force.
And that maximum force was the universal injunction.
Exactly that. All 3 district courts issued these universal injunctions, which meant they told executive officials, you cannot apply this executive order to anyone in the entire country, not just the specific people who filed the lawsuit.
Wow. Okay, so a complete halt.
A complete halt. And the government immediately appealed. But here's the crucial part. In their emergency request to the higher courts, they didn't really defend the EO's constitutionality at that stage. They challenged the scope of the remedy itself. They basically said to the Supreme Court, hang on, a single district judge can't just block a national policy for the entire nation based on the claims of, a few plaintiffs.
Okay, let's pause there and really unpack this key concept. The universal injunction. It sounds powerful. How do we define it simply? And why did the government see it as breaking the traditional way courts provide relief?
Right. So a universal injunction, sometimes called a nationwide injunction, it's a court order that stops the government enforcing a policy against anyone, anywhere in the U.S. Traditionally, if you sued the government and won, an injunction would protect you, the plaintiff.
Yeah.
The court stops the government from enforcing the law against you.
Oh.
A universal injunction says stop enforcing it against everybody, even people who never went to court.
That sounds like a huge difference. And the government argued this creates serious problems, sort of systemically, regardless of whether the policy itself is good or bad.
Yes, they raised several major policy concerns. The first big one was asymmetry.
Asymmetry, meaning?
Meaning a plaintiff challenging a policy only needs to win once, find one sympathetic district judge somewhere to get a nationwide halt. But the government, trying to defend its policy, has to win everywhere. If it gets sued in multiple places, losing just once can stop everything, but winning multiple times doesn't necessarily guarantee the policy stays in effect if there's still one injunction out there.
That seems like it would really incentivize trying to find that one friendly judge, what we call forum shopping.
Exactly. That was our second major concern, forum shopping. If winning in one court means the entire nation gets the benefit of that ruling, plaintiffs have a huge incentive to file their case strategically. Find a district judge they think is most likely to agree with them, and that one judge effectively becomes a national policymaker, at least temporarily, bypassing the whole appellate court process in a way.
Right, leapfrogging the system. And besides that, was there a third big concern about how these injunctions affect the courts themselves?
Yes, the third point was about rushed decisions. When a single judge issues a nationwide halt to a major federal policy, it creates this emergency situation. It forces the entire federal court system, all the way up to the Supreme Court, to deal with massive legal or constitutional questions on an emergency basis, often through the stay process.
Like a fast and furious approach, you said.
Exactly. You end up making huge decisions without the full briefing, the oral arguments, the careful deliberation that complex cases really deserve.
Okay, so here's where, for me, it gets really fascinating. The Supreme Court takes the case. Here's all these very modern, practical arguments, form shopping, asymmetry, rushed dockets, but then they seem to largely sidestep them.
They did, to a large extent.
And instead, they focused almost entirely on legal history, going back to, the very founding of the country.
That's the absolute core of the majority opinion, which Justice Barrett wrote. The central legal question they decided was historical. Did Congress, way back in the Judiciary Act of 1789, actually give federal courts the equitable authority to issue these kinds of universal injunctions?
Wait, seriously, so the chaos these injunctions might cause today wasn't the main driver. They cracked open law books from 1789 to decide a 21st century procedural issue. That feels really odd.
It can feel counterintuitive, absolutely. But that's the legal doctrine the court majority applied. It's called the historical test. It basically says that the power of federal courts to issue equitable remedies like injunctions is limited to the kinds of remedies that courts of equity in England traditionally offered back when the U.S. was founded, around 1789.
Okay.
And the majority looked back and concluded, essentially, that this kind of universal injunction was conspicuously non-existent for most of our nation's history. Traditional equity, they argued, was fundamentally party-specific. It helped the person in court, not necessarily everyone outside the courtroom.
So if I went to court back then, the chancellor might stop someone from harming me, but wouldn't issue an order protecting the whole town.
Broadly speaking, yes. The plaintiffs tried to argue that maybe the universal injunction was just the modern version of an old group litigation tool called a bill of peace. But the majority completely rejected that comparison.
Why? What did they say was the real modern equivalent for handling group claims?
They pointed squarely at the class action, governed by Rule 23 of the Federal Rules of Civil Procedure. That, they said, is the proper established way to get relief for a large group.
Okay. So the court saw the universal injunction as kind of an end run, a shortcut around the strict requirements needed for a formal class action, like proving the class is numerous, that they have common issues, all that stuff.
They absolutely viewed it as impermissibly circumventing Rule 23. It wasn't following the established procedural rules for broad relief.
That distinction makes more sense when you bring up that nuisance analogy you mentioned earlier. Let's try that.
Okay, think about it this way. Imagine your neighbor plays incredibly loud music late at night. A nuisance.
Right. Annoying.
You sue them. The court agrees it's a nuisance and issues an injunction ordering your neighbor to turn the music off, specifically to protect you.
Okay.
Now, does that order help your other neighbors on the street? Yes. Incidentally, they benefit from the quiet. But the actual legal protection, the injunction itself, only extends to you. Only you can go back to court if the neighbor violates it.
Got it. The benefit might spread, but the legal right is personal.
That's the key distinction the court drew. They said complete relief is the most a court can give to the parties in front of them. But crucially, complete relief is not synonymous with universal relief. So in the citizenship case, stopping the EO from being enforced against the child of the specific pregnant woman who sued, that gives her complete relief. Extending that ban to every other unborn child in the country, the court said, doesn't make her relief any more complete. It goes beyond helping the actual parties.
Okay, that clarifies the impact on individuals. But what about the states? Washington, New Jersey, others were plaintiffs too. They had a pretty strong argument that they needed a universal injunction, didn't they? For practical reasons.
They did. They argued that a partial injunction, one that only protected, say, children born to the specific members of the plaintiff organizations, would just be unworkable for them as states.
Unworkable how? What were the specific problems they foresaw?
Well, think about the logistics. Imagine a child is born in state A, which isn't a plaintiff, so under the EO, maybe they aren't considered a citizen. Then that family moves to State B, which was a plaintiff state where the EO was blocked. State B is now stuck dealing with the administrative nightmare. Does this child qualify for state-run programs funded by federal dollars like Medicaid or CHIP? Which rule applies? It creates massive confusion and potential financial burdens.
Yeah, that sounds like absolute administrative chaos. A compliance headache for state agencies, for families, just constant uncertainty depending on where you live or if you move. This must be the patchwork injunction system they were worried about.
Precisely that. The states basically said, look, we can't run our systems fairly or efficiently if the fundamental rules of who is and isn't a citizen change when you cross state lines because of these partial court orders.
So how did the Supreme Court respond to that practical argument from the states?
Well, interestingly, the court kind of punted on that specific question, at least for now. They declined to make a final ruling on whether the states truly required a universal injunction to get their own complete relief.
They punted it, so they sent it back to the lower courts to figure out.
Essentially, yes. The Supreme Court issued what's called a partial stay. This means the injunctions blocking the EO are now narrowed. They only protect the original individual plaintiffs and the members of the plaintiff organizations. Then the court told the lower courts to go back and figure out on remand whether a narrower injunction, maybe one just blocking enforcement within the borders of the plaintiff states, would be sufficient to give those states complete relief from their administrative problems.
Okay, so what does this mean, practically speaking, for you, the listener?
Yeah.
If you're a citizen or maybe part of an organization thinking about challenging a federal policy in the future?
Well, the immediate impact is clearly a win, at least partially, for the government in terms of limiting judicial power. That executive order cannot be enforced against the specific people and groups who already sued and won in the lower courts. But for everyone else, the general public who weren't part of those specific lawsuits, the legality of the EO regarding them is basically up in the air again. Its application now depends heavily on what happens next in the lower courts, and it could potentially create that very patchwork system the states were so worried about. Different rules in different places.
And it sounds like the path to getting broad relief, stopping a policy nationwide, is now much harder. It has to go through the formal and probably much slower class action process under Rule 23.
That seems to be the required path forward now for that kind of broad nationwide remedy. And it's important for you to realize, class actions are demanding. They aren't easy. You have to meet strict procedural hurdles, proving enough people are affected, numerosity, that they share common legal or factual questions, commonality, that the lead plaintiff's claims are typical, and that they'll adequately represent everyone.
Right.
This can turn a challenge that might have been resolved relatively quickly with a universal injunction, maybe in months, into a complex, multi-year legal battle demanding significant resources.
Okay, let's try to wrap this up then. The main takeaway from Trump v. Case Hawks seems to be that the Supreme Court has significantly reined in federal judges. They've effectively stripped them of this powerful tool, the universal injunction, justifying it based on a deep dive into, well, 200-year-old legal history and equitable traditions.
That's the bottom line. This decision definitely shifts the balance of power, arguably back towards the executive branch somewhat. It makes challenging federal actions on a broad scale harder, slower, and likely more expensive, channeling those efforts into the more rigorous, structured process of class actions. You know, the dissenters in this case made the point strongly that under this ruling, the executive branch might be able to enforce what could be an unconstitutional policy against potentially millions of people, at least for the time it takes for a class action or multiple individual suits to work their way through the system.
Which really brings us to the final big question this deep dive leaves us with, doesn't it? The court's decision hinges on this idea that judicial power has historical limits courts must respect, even if they're faced with an executive action that many people believe is, quote, unquestionably unconstitutional. So the provocative thought for you to consider is this. Does upholding judicial procedure, even procedure rooted in centuries-old practice, always outweigh the potential harm of, let's call it, potentially unlawful government action, even if only for a temporary period while the slower legal processes unfold?
A fundamental question about checks and balances in our system.
Exactly. Something to mull over as we watch how this plays out in future challenges to federal power.